Hi, folks. I'm Greg McLawsen, the Affidavit of Support lawyer. I help green card holders enforce financial rights under the USCIS Form I-864 Affidavit of Support. In federal litigation and all litigation, discovery is the process where both parties are entitled to discover or learn information from the other side of the lawsuit. Lawsuits are basically based on two things. They're based on the facts and the law. And the discovery process is where both sides have a legal right to assess the facts that underlie the other party's case. So if you are a plaintiff bringing a lawsuit to enforce the affidavit of support, discovery is the process where the defendant gets a chance to see what your case is made about. And a lawsuit to enforce the affidavit of support basically consists of two sets of facts. How did you immigrate to the United States? It involves sponsorship by the defendant. Number two, what is your income? Because at its core, a lawsuit to enforce the affidavit of support is really fundamentally about the income of the plaintiff, because that is what determines the damages that a court can award to the plaintiff. So let's talk about 10 rules for going through the discovery process in an affidavit of support lawsuit. Number one is that it is the client's job to provide me, their attorney, with facts, and it's my job to deal with the legal issues about what the defendant can and cannot ask us. The plaintiff, my client, is the person who this lawsuit is about. You know about your life, and I don't. I don't have any magical way to know specifically what your income has been and what your finances have been, and those are the key facts of the lawsuit. The defense is going to ask us questions about your income history. Why? Because that's what the entire lawsuit is about. They're entitled to do that. Your job as the client is to answer the questions that the defense has propounded, not to the defense, but to tell me. You give me the factual response to those answers, and then I, as the attorney, will make a determination about whether their question is legally appropriate, whether we need to make an objection or not. But that's my job. Your job is to provide the facts, which I have no way of ascertaining without your cooperation. Number two is you've got to be complete in your answers. Always err on the side of providing me with too much information. It's very easy for me to say, okay, my client has provided me with more explanation than we need to provide in written discovery responses. And so when I'm preparing final responses to the discovery, I'm just not going to include that detail. If you leave something out, that is a different story, and it potentially creates a problem that cannot be fixed down the line. So just for example, if a defendant asks us to identify all of my client's bank accounts, because again, this is about what money my client has been earning. If we don't tell them about a bank account because let's say it's located in a different country and the client thinks that's not what the question was about, if we leave that information out, it could result in penalties imposed by the judge, potentially including financial penalties against my client and even dismissing the whole lawsuit. So you always want to provide more information to your attorney. Let the attorney decide what does and doesn't need to be disclosed. And they're going to ask a lot of questions, and that is their right. At its core, again, a lawsuit to enforce the affidavit of support is about your income history. So you can bet that the defense is going to ask detailed questions about your finances. Now, they're not simply going to ask, tell me what your income has been, because they, especially their attorneys, are going to be prepared for the possibility that you are lying. And they are entitled to probe the veracity of the allegations that we've made about income. So they're not just going to ask, tell me how much you earned last year. They're going to ask to see your bank accounts because they want to see money that's coming in and out. They're going to ask if you've gotten money from friends or family, and they may even send questions to those third parties. You need to be prepared for the fact that this is a lawsuit about your finances, and your finances are going to be fair game during the discovery process. That is not a matter of the defense abusing the litigation process. It's just that this lawsuit is fundamentally about your financial situation, and so you can expect questions about your finances. Organization in the discovery process is key. The two primary types of questions that we are going to get from the defense are interrogatories. That's a question that gets an English language response typed out. Separately, requests for production of documents, sometimes called RFPs, are exactly what they sound like, a request for us to produce a particular type of document. Those responses can get very unwieldy. We might be looking at hundreds or even thousands of different documents that respond to those requests for production. So it's absolutely critical that you provide organized responses. You will receive from me an organized folder hierarchy that says request for production 1, request for production 2. And when you provide responses, it's really important that the material be organized with respect to the RFP that you are providing responsive information to. So if RFP 1 asks for your bank accounts, you need to put your information in the folder number 1 that responds to that to that request for production. To say it again, it is my job to object to discovery requests that are improper. What is very important is that we have a relatively tight timeline for responding to discovery. Typically, it's 30 days from when we receive the requests. What we do not have time for is to go back and forth and back and forth and back and forth and spend a week trying to identify whether you are going to participate and respond to the discovery requests. I need immediate assistance with you preparing the factual information that responds to the interrogatories and requests for production. And while you are working on that, I will be assessing those requests and determining whether we need to object to them or not. But it's important that these processes go on at the same time. Me doing my job, preparing the legal objections, and you doing your job, which is preparing the factual information. Even if we end up not disclosing certain financial information to the other side because it's not necessary, it may still be helpful for me in understanding your case. So please provide the responsive information. That does not mean that it's automatically getting disclosed to the other side, but this is time sensitive and I need to do my job while you do your job. If we do not respond to discovery in a complete, honest, and thorough way, that can have consequences. The entire lawsuit can be dismissed for being non-compliant with the discovery process. Short of that consequence, there can also be financial penalties. And above everything else, we don't want the judge to get a sense of us being uncooperative in the litigation process. The entire discovery process is set up for the parties to be cooperative with each other. And judges tend to be very harsh in penalizing parties to litigation who are not cooperative in the discovery process. So our golden rule, our guiding principle for discovery is that we are honest and complete and that we comply cooperatively with the discovery process. Again, finances are absolutely key to your claim under the Affidavit of Support. Even though questions about your bank accounts, credit card statements may implicate information that you find to be sensitive, we are generally still going to have to provide financial documents and answer questions about finances because those are core issues in this litigation. If there are specific concerns you have about your finances, we can certainly discuss those. I'm happy to do that. But in the big picture, this is a case about your financial situation. And so questions about your finances are going to be fair game in the litigation process. Some of these lawsuits under the Affidavit of Support go on for a year or more. Almost all of the work that is done in these cases is work that I do as the attorney. Drafting the lawsuit, presenting arguments to the judge, most of the work is on me. The main exception to that is the discovery process. That is the number one part of the lawsuit where cooperation and assistance from the client is absolutely critical. Because again, you know about your life and your finances, and I don't. So I cannot advance the case without your complete and thorough assistance in the discovery process. Discovery isn't fun. And believe me, I don't like it either. But what you should focus on is the fact that this is the main point in your case where you can be the most help, where your help is the most critical. So please focus on getting through the discovery process, focus on providing timely responses to your attorney, and most of the rest of the work is going to be on my shoulders as the attorney. If you've been through a divorce process, you may have experienced the discovery process before. And in a divorce, both parties ask for pretty similar information from the other side. That's because similar information is legally relevant to both parties. That is not the case when it comes to the Affidavit of Support. Your legal claim under the Affidavit of Support depends, again, on was the Affidavit of Support signed? That's usually not a serious factual question. And then number two, what your income has been since you became a green card holder. The sponsor's income is not directly relevant. Your damages, what a judge can order, is based on the difference between your income and 125% of the poverty line. The sponsor owes the same amount of money regardless of what their income is. Now, there are stages in the litigation process where we absolutely are going to need to know about their finances. And we typically do propound discovery about some aspects of the sponsor's finances because it's relevant to their ability to pay and needed for the mediation process. But we do not engage in this sort of tit for tat back and forth in discovery. And we are not going to ask questions of the defense merely because they ask them of us. Because, again, what is relevant to the defense fighting off our claim is not the same thing as what is relevant to us as the plaintiff bringing the lawsuit. So don't expect that our discovery requests are going to be the same as theirs. That's not a mistake. It's just because different things are relevant to different parties. Discovery isn't fun. I've said that before. It's in fact my least favorite part of litigation, but it's a normal part of litigation. Extensive questions and the requirement to provide extensive information is simply a normal part of the litigation process. And by the way, the scope of discovery in these affidavit cases is far, far more limited. Actually, it's more limited than a divorce case, but it's certainly more limited than your average piece of federal litigation. What we have to do for the discovery process is simply get through it. That's what we have to do. We have to understand their questions. We have to prepare the factual response. That's your job. I have to provide objections where necessary. And then we move on. So we just have to knuckle down, get through the process, And what we do not want to do is to create battles over issues that are not going to help us achieve our goal. So there may be times when we could create a fight and object to a discovery question. And we might choose to simply respond to it, not because we think it's something they're really entitled to, but it's just not worth the battle. And we will lose more credibility with our judge fighting over an issue that doesn't matter than we will simply providing information and moving on. Because at the end of the day, what we care about is winning the lawsuit. That is the only goal that we are out to accomplish. And spinning off ancillary legal battles about discovery that don't matter, it doesn't help us. It doesn't improve our litigation posture, and there's no reason to do it. Hopefully that's helpful. If there's one core message, it is this. The client's job is to provide complete factual information to their attorney. It is the attorney's job to be worried about what is legally relevant and what legal objections have to be made. And because the discovery process is time sensitive, it's important that the client get started right away providing factual information to the attorney so that the whole process can be completed in a timely manner. Hope that's helpful. Take care.